Hi, and welcome to today's session, where we'll be covering the completion of the audit and reports. We'll first start with the definition of a contingent liability. What is a contingent liability? It is a potential obligation that depends on the outcome of a future event. For example, a court case or a damages payout. The primary source of information concerning litigation claims and assessment is client's management. And the primary source of corroborative evidence is the client's legal counsel. Additional sources include corporate minutes, contracts, correspondence from government agencies and bank confirms. These contingent liabilities should be recorded in the accounts if it is probable and the amount can be estimated. What do we need to consider in the final review stage of the audit, in addition to those contingent liabilities? Well, contingent losses that are both probable and reasonably estimated should be accrued and disclosed. Losses that are reasonably possible and remote contingencies disclosed because of common practice, and they should be disclosed in the notes to the financial statements. Other contingencies include litigations, warranty liabilities, purchase and sale commitments, collectability issues, guarantees, obligations of banks, agreements to repurchase receivables, and threat of expiration of assets in a foreign country are all considerations in the final review stage of the audit. Who has the responsibility? Well, management is responsible for identifying, evaluating, and accounting for the contingencies, whereas the auditor is responsible for determining the client has properly identified and accounted for them and disclosed them. A solicitor's representation letter is a primary source of corroborative evidence concerning litigation claims. The representation or letter of inquiry needs to include management's description, a request that the lawyer furnish the auditor with a comment on the completeness of management's list and evaluations for each contingency, and provide a potential estimate of loss or a likelihood of an unfavourable outcome. This is documented in ASA 508. This is good for establishing the completeness of potential liabilities and providing factual information about contingencies. But because audit work papers are not privileged, lawyer responses will be less than forthcoming about the likelihood of unfavourable outcomes and the estimated amount of potential losses. They'll be hesitant to give too much information to auditors. A lawyer's refusal to provide the information is a scope limitation sufficient to preclude issuing an unqualified opinion. We now discuss subsequent events. Post-balance day events should be reported in the financial statements if they are significant and relevant to users. Non-adjusting events arise from circumstances that were not in existence at year end. And if they are material, they need to be disclosed in the notes. Well, how an auditor handles it depends on two things: whether the subsequent event provides evidence about conditions that existed, type 1, at balance date, or conditions after, type 2. Type 1 events provide evidence about conditions that existed at balance sheet date. Such examples of this include a major customer whose deteriorating financial condition existed prior to balance sheet date. They filed for bankruptcy, or there's a settlement of a law case or a bonus share issue. In this instance of type 1, financial statement numbers should be adjusted to reflect this information. Footnote disclosures may also be necessary. Whereas type 2 events, they did not exist at balance sheet and hence should not be adjusted, but should be considered for disclosure. Examples of this are a significant lawsuit initiated for an incident occurring after balance sheet date, or a natural disaster after balance sheet date, or major decisions such as a decision to merge, etc. The audit procedures that are used to identify subsequent events include reading minutes of meetings of the Board of Directors and reading interim financial statements and investigating significant changes. Inquiring of management about significant changes in the interim statements, contingent liabilities, etc. Or inquiring of management lawyer about subsequent events, or obtaining a management representation letter. If the subsequent event occurs after end of field work, but before the audit report is issued, the auditor must decide whether to single or dual date the audit report. In the case of a single date, the date of the subsequent event is the audit report date. The auditor must make sure there are no other subsequent events prior to this date. A dual data report uses the dates of the end of the fieldwork and the subsequent event. The auditor has no responsibilities to continuing obtaining audit evidence after the end of the fieldwork unless something comes to their attention. If there are subsequent facts that are discovered after the financial report has been issued, the auditor must determine the reliability of new information, whether the event occurred by the audit report date, whether users are likely to still be relying on the statements, and whether the audit report would have been affected had the facts been known. We will now discuss management representation letters. The main objective of these representation letters is to confirm in writing representations or responses made by management. It's a reminder to management of their primary responsibility for the financial report, and it reduces the possibility of misunderstandings, and must be obtained in each audit. This letter is prepared by the auditor on a client letterhead addressed to the auditor and normally signed by the CEO and CFO. It's dated the audit report date and is usually prepared by the auditor. The report certifying the financial report signed by the CFO and CEO accompanies the financial report in the annual report to regulators and shareholders, whereas the management representation letter becomes part of the auditor's documentation and is not disseminated to others. Because they are not strong evidence, the auditor should perform procedures to corroborate the information in this letter. Management's failure to provide this letter is a scope limitation. As previously mentioned in another session, the client will need to post the adjusted journal suggested by the auditors. If the client refuses to do so, the auditor must decide on its materiality. If it's not, the statements aren't going to be distorted by not including them, the audit report should be qualified. Audit evaluation and conclusions. Once the auditor has made a final check of the working papers, they need to prepare the audit report. The auditor should also send a formal letter to management outlining certain aspects of the audit. The auditor is required to evaluate the going concern. And again, as we have previously mentioned, indicators of potential going concern problems are as follows. If there is a doubt of the ability of client to remain in going concern, the auditor should do the following. And consider the effects on the audit report. They might need to add an explanatory paragraph, disclaim opinion, or issue a qualified opinion. We'll now look at the elements of the audit report. The auditor, most importantly, needs to form an opinion to say whether statements are drawn up properly or not, to give a true and fair view of the company's transactions and state of affairs, to ensure it's in accordance with the Corporations Act, in accordance with accounting standards, and based on the maintenance of proper accounting records. AASA 700 covers the audit report of the financial reports and provides guidelines on its structure. It must include the following: types of audit opinions. The auditor's opinion should be either unmodified or modified. An unmodified opinion is expressed when the auditor is satisfied that financial statements give a true and fair view of the client's financial position. A modified opinion is expressed as either an except for opinion, an adverse opinion, an inability to form an opinion. AASA 705 sets when a modified opinion is warranted. For example, there may have been a disagreement with management, a conflict between accounting frameworks, or a limitation on the scope. There are certain circumstances that result in a qualified adverse disclaimer opinion, and these are listed in the table below. So there is a difference between a scope limitation and uncertainty. A scope limitation prohibits the auditor from performing audit procedures due to client's instructions or circumstances. For example, the client telling the auditor not to confirm receivables. Whereas an uncertainty is a situation in which there are no audit procedures that can be performed because the evidence does not yet exist. For example, pending litigation. So what does the auditor need to consider when determining whether the financial report is presented in conformity with the Australian accounting standards? They must consider whether the accounting principles have a general acceptance, the appropriateness of them, whether financial statements including the notes are informative, whether the information presented is classified and summarised in a reasonable manner, and whether the notes reflect the underlying events and transactions. This, along with the audit opinions, will be discussed in further detail within class. Thank you for your time.